Ready when you are. It's my first day. Well, welcome everyone. My name is Clark Freshman. I'm a professor of law here at UC Law SF, formerly known by another name for someone whose name, like in a movie series, will not be spoken aloud. So I'm very happy to introduce Cynthia, who's the director of the Criminal Law Clinic and at Texas A&M program. Sorry about that. And also bridges uniquely one of the neglected areas in dispute resolution, which is between the criminal system. I just learned not to say criminal justice system because it may not involve as much justice. So the criminal system and different types of dispute resolution. And so today she'll be talking about a very interesting topic, which is why it is that so many people in the prison system, most of whom I learned today are there just for misdemeanors, about 80%, although it's a little bit hard to crunch the numbers, which I can sympathize with, are not able to securely communicate with their clients. So she'll be talking partly about the problem, and then also partly about what are some ways, either through dispute systems design or through the efforts of various actors, to try to remedy this problem. So thank you very much for traveling to join us. And I should also mention an alum of this very law school. When it had a different name.
Yes, so it's wonderful to be here. And of course, as you, I think, often hear from people who haven't been here in a few years, I don't recognize it, right? Because we're all in the building, which is wonderful. So this paper is a work in progress, so I welcome thoughts, suggestions, anything that you may be thinking about as you hear it. Some people in the room, I think, have read the paper and some haven't. So I'm going to try and just give a basic overview of what this paper is about, and then hopefully we can open it up for discussion for more of the time here. As Clark referenced, right, in our criminal legal system, about 80% of cases, not necessarily 80% of people incarcerated, are in on misdemeanors. But what I'm focusing in on in modernizing attorney-client jail communications is what's happening mostly at the pretrial level and for people who are being detained in jail, and whether or not they have an ability to speak confidentially with their lawyers. So I think generally when we think about attorney-client confidentiality, we think of things like this quote from a Supreme Court case, that confidentiality is protected, there's a public interest in encouraging full and frank communication between attorneys and their clients. And that's, I think, particularly for the uninitiated, but I think also in general, it's how we think it is and should be, right? That lawyers' communication with their clients is protected. We understand that there's a reason for that protection in terms of a greater public interest. In reality, and I'm going to give you a couple of quotes from, I did a survey in the early months of the pandemic. And one of the questions I asked of the defense lawyer respondents, and it was a nationwide survey, so I'd responded to the country, was what was going on with attorney-client communications during the early months of the pandemic. And one of the responses I got back was, we have confirmed cases of deputies recording attorney-client video meetings and turning over those recordings to police and prosecutors. And to put it in context, that confirmation and the recordings happened before the pandemic. So it wasn't that it was only during the pandemic, this was before, which led to widespread distrust by a lot of defense lawyers in the country of how things were working when they were forced into electronic communications with their clients, or not communicating with them. Another quote, special sections of the DA's office listen to jail calls between lawyers and their clients on a regular basis. So, do we need it? Okay, sorry. I was saying I could talk loud enough, but apparently not, so that's good. So we'll use the microphone. So one of the things that I think is important in these quotes is to recognize that when the pandemic hit, and we know that it hit hardest in jails, prisons, and senior living places, right? These were the hardest hit parts of our society. And the courts shut down, and I'll talk about that in a minute, but one of the things that also happened is attorney-client communications with their clients were sharply curtailed, and the only way in which lawyers could figure out how to communicate was based on also what they knew from what was already happening with communications prior to the pandemic. So why does it matter that defense lawyers have such little trust in the confidentiality of electronic communications, which I include to mean phone calls, not just video calls and not just email communications, which are, it's much less email communication happens. Well, it matters for some basic reasons that I think we all know, right, as lawyers and lawyers to be, right? Lawyers need to meet with their clients to build rapport as a standard part of the attorney-client relationship. They need to gather information about the client and the case, and oftentimes the only way to gather that information is by actually talking to the client and building the rapport so that the client will trust enough to give information that they might not otherwise give. Lawyers need to counsel their clients, and including discussing options such as plea offers. Our criminal legal system depends on plea bargaining for cases to be processed. Well over 90% of resolved criminal cases are resolved through plea bargaining. It's not through trials. A very small percentage of cases go to trial. And plea bargaining depends on attorney-client communication. Attorneys need to be able to speak with their clients, not only to find out what they need to know going into the plea bargaining process, but to counsel them about any plea offers that are made, and offers are made in the vast majority of cases, so that clients can make decisions about whether to accept those offers or not to accept them. So when we're talking about jail attorney-client communications, there's basically 4 ways that it happens. So we've got in-person communication, and this is kind of how we stereotypically look at it. We'll talk about whether that's really how it happens a lot of the time, but we've got a nice private room in a jail facility, so the lawyer can come in and meet in person with their client in relative privacy. Phone calls are another way in which lawyers are regularly communicating with their clients, often for much smaller and defined things, as we'll talk about. And one of the pieces that I talk about in the paper is a survey that predates the pandemic, asking how lawyers communicate with their clients, and it's these 4 responses that they were saying before the pandemic. There are letters, and generally with attorney-client communication going into jails or prisons, it's listed clearly that that's what it is. It should protect it from being opened and monitored. There may be opening that happens in front of the defendant, and there can be other circumstances that can compromise the confidentiality of it. But generally, it's a more trusted form of communication by defense lawyers with their clients. But it creates a lot of problems because, first of all, it's slower. There's nothing immediate about sending a letter through the mail. And second of all, a lot of clients may have limited literacy skills. Lawyers and clients may not share a language, so there's complications in terms of how they're able to communicate there. A significant percentage of people who get pulled into our criminal legal system have some sort of cognitive disability, which may make it harder for them to process information that's sent in the written word and in the form of a letter. And then the final, which has increased the numbers, but it's still not as available as it is to us in the outside world, is video calls. Right. So those are the 4 basic ways in which attorney-client communications happen in jail. And there's a strong preference from lawyers to meet in person because of concerns about confidentiality, and we'll talk about that. So when the pandemic happened, one of the things that I think we all know was a part of what went on during the pandemic is the courts shut down. By March 2020, all courts in the country had issued shutdown orders. And included in that was that jails shut their doors to outside visitors. So it was impossible to get into the jails to visit for a period of time, and the courtrooms themselves the courts themselves were shut down. And it is stunning because there's hardly anything that our criminal courts do across the board in this country, one thing, which shutting down in that way is a stunning difference. Although, of course, they shut down differently. So the courts closed, but they were still operating. There were still things that needed to be done. People were still getting arrested throughout the pandemic, including in those early months. And so they needed to be arraigned. They had rights to arraignments, rights to bail hearings, and there may be other processes. And so these are just a couple of things that show some of the video arraignments that were going on, video bail hearings. And you can see it's different, right? In this one, you've actually got some people standing physically in the courtroom and the defendants physically in the courtroom, but The judge isn't. That was one of the responses. The judges were ordering defense lawyers to come to court while they were staying on Zoom. There was some concern about the inequities of that. Or you've got this kind of a situation where you've got kind of mass arraignments going on in the jail facility itself, if you look in the upper right-hand picture there. And there's serious concerns about what people could hear and how and then there weren't lawyers in the jails with them as they were being arraigned or bail hearings were happening. And another thing that was a piece of what was going on during the pandemic was serious case backlogs, because although the courts were still doing some basic things, they weren't necessarily resolving cases. There were no jury trials for a long period of time. And even though a small percentage of cases go to jury trials can act as a point of leverage to get plea negotiations concluded. And when all the time limits were removed, it stopped that kind of pressure to get cases resolved. And then there were a variety of other issues that led to case backlogs, including the challenge and how hard it was for lawyers to talk to their clients and do simple things like convey offers if offers had been made. And during the pandemic itself, there were very limited options. During the early months of the pandemic when the court shut down, there were very limited options for communication between lawyers and their clients. So there were letters, snail mail, right? That was an option. And then there were phone calls, video calls. And the problem with that is there were all these very serious concerns about confidentiality. It was not something that lawyers in large part felt they could trust and that they could use. I did this nationwide survey. The question, I asked a variety of questions, but one of the questions I asked specifically to defense lawyers is how was the pandemic impacting their ability to talk with their clients? And this, were they concerned about confidentiality, yes or no, and then why? That question got more written responses than any other single question in the survey. And as I mentioned to the class I was just speaking to, I think the most accurate description of those written responses was that the defense lawyers were apoplectic about the situation that they were facing, that they were forced to choose between having a confidential communication with their client or living up to their other duties in terms of communicating with their clients, conveying offers, and doing what they needed to in order to handle the case for their clients. That they couldn't do both at the same time because of the circumstances, because they were forced into these two options, either letters or video or phone calls. And as in most things, right, the pandemic highlighted existing problems and pointed out problems that were already serious and were already something that should have probably, in fact, certainly been dealt with before the pandemic. So there was widespread failure before the pandemic to protect confidentiality in electronic phone and video communications between lawyers and their clients. There have been a number of lawsuits before the pandemic about the failure to protect confidentiality, including some here in California. And the private telecom providers, there's two companies that have cornered most of the market in this area. They've both been sued multiple times in a variety of states, and still it's an issue. And the way in which these cases had been handled before the pandemic, and then there was one class action lawsuit during the pandemic, was case by case. They may be class action cases, but they were essentially case by case, jail by jail, in terms of how things were being fought when there was a failure to protect attorney-client communications. And there are a variety of other confidentiality concerns that are a piece when we're looking at how lawyers can communicate with their clients. So there is more access to video communications now than there was when the pandemic started. It was one of the things, there was an increase in some places in access to video communications coming out of the pandemic. And this is how we tend to look at it. Someone's sitting in a private area, they're talking directly into one of these machines, they're able to have video communication with their clients. But one of the problems is you don't see the full picture. This is often how it really looks. There's nothing confidential about that at all, right? There can be a jail guard standing right there. Other people who are being detained can listen in on the calls. You have no way of knowing what's going on when, as a lawyer, all you're seeing is that first picture. Right? You don't see the full picture of what's going on, which is one of the reasons, and it's something that certainly came out in my survey, that lawyers don't trust the video communications because they know there's a lot of things going on that are impacting the confidentiality of these video communications, and they can't assess it. When you go into a jail visiting room, and you can assess what's going on. So this is LA County Jail, pretty standard setup. You've got a bunch of guys on one side. They're able to talk into a phone and talk to lawyers on the other side of the glass. Sometimes it's open without glass. But a lawyer coming into that situation can assess it. They can say, okay, I know this is not going to be fully confidential, and it'll change what they may or may not talk about at that moment. And they may say, I just want to give you information because there's so many ears here. I don't want you responding yet. Let's wait till we can talk about it privately, right? But it's hard with the video or phone calls. The lawyer can't assess. They have no idea what other ears may be out there listening in on the conversation. So one of the things that I think is important in looking at this is the impact that this is having the lack of reliably confidential attorney-client communication, the lack in electronic communication is having on our criminal courts. So first of all, as I've mentioned, as I think everyone knows, right, our criminal courts rely on plea bargaining for case processing. This is how things get resolved for the most part. And as I've said, right, plea bargaining relies on attorney-client communication. And when we don't have reliable, confidential forms of communication, it impacts court efficiency. And the lawyers, if the only way that they can talk confidentially with their clients, now that the pandemic has receded, that jails and prisons are open, people can go back and do in-person visits. So lawyers, for the most part, have gone back to in-person visits. In-person visits are very time-consuming. You have to drive to wherever the jail facility is. So San Francisco County is a fairly contained county. I was a public defender in Los Angeles County. That's a far less contained county. There are jails that are an hour or more away from whatever courthouse you may be assigned to. So it's a 2-hour visit without even having spent any time with your client. It's two hours just in transportation. Then there's the amount of time that you spend. Once you go to a jail, you have to go through whatever the security procedures are in the jail, lock up your phone, whatever it is, go into the interview rooms, wherever those are, however they're set up, and wait for your client to be brought, however long that takes, right? And all of this is very time-consuming, and we're doing this on the backs of defense lawyers that, as we know, are generally have high caseloads, higher caseloads than anyone is recommending that they should have. There are very few places in this country where defense lawyers, particularly public defenders, have the caseloads that they should be having to provide competent representation. They're usually representing a lot more people than they should be, which means they've got a lot less time for each person. And when you add on to it the time-consuming nature of going and visiting, what often happens is they're not. They may be waiting until the defendant is brought to the court and having conversations in the court. I know in Los Angeles County, one of the ways that I regularly dealt with it is I would set court dates so they could bring my client in. So I would be able to have conversations in the court because there was no physical way I could get out to, say, the Lancaster jail to be able to visit and have the conversations that I needed to have with them, along with everything else I needed to do. And all of this impacts the efficiency of the courts, and I don't think efficiency is the holy grail, but at the same time, when things are very inefficient, it also impacts justice, right? When it takes a long time for cases to get resolved, it impacts the kind of justice that we're seeing in our legal system. So there's a lot more I could talk about this. It may come up in the conversation, but I wanted to just lay the groundwork of what's the concern, what are the problems. And then the question is, at this point, well, what can be done, right? And there's a variety of things, and I don't think anytime we're talking about our criminal legal system, we've got simple solutions. It's complex. There's a lot of different players involved. But I think there's things that can be done that could improve the situation, that could make it better for criminal defense lawyers and their clients. So one is if we were to take more of a dispute system design approach to looking at this problem, currently, courts I think often have very little planning, or their planning is not necessarily long-term, and it's often not what we would consider a good approach to planning, such as dispute system design. And in dispute system design, one of the key pieces of it is that you bring all the stakeholders together to talk. And to find out what is it that their interests are, what are they concerned about, what are the things that might help for them to be able to do what they need to do within whatever system or dispute that we're talking about. And overall, our criminal courts have not done this. There tends to be more of a focus on short-term planning. One of the things that we saw during the pandemic is most courts were going back to basically their continuity of operation planning, which is a short-term approach to planning for emergencies. So things like when Hurricane Katrina hit, so you would go into your continuity of operation plan. How do you operate for a few days under a crisis of a storm or maybe a terrorist attack? But the pandemic, as we know, lasted well over a year in terms of disrupting court operations in this country. And the continuity of operation plans didn't take that into account. And most of them didn't include any discussions with the defense bar. And this is another outcome from the survey that I saw time and again, was concerns by the defense bar that they weren't being consulted. And part of what that means is the court's looking at what the court's looking at, right? And the courts are viewing it through the lens of what they see coming before them and what they think should be happening in order to improve overall how the courts function. And I think there's a blind spot here. They're failing to see why helping defense lawyers to be able to do their job helps them, right? And it matters for the courts to be to have that in their view. It also means that it's time to move beyond a case-by-case approach. It shouldn't, looking at getting better and systemic solutions to problems of attorney-client communication shouldn't rely on individual cases being filed, even when they're class action cases. Right? That's a very limited way of looking at it. It means you've just got county by county, jail by jail, actions being taken, and you're not looking in a bigger picture way, how can we improve things, and approach it from, as I said, the systemic level. And generally, the way we've been looking at it right now is we put all the burden on the defense bar. It's up to them to raise that there's a concern, and it's up to them to bring forward the cases. Instead of saying, no, this is something that our criminal legal system has an interest in, we should be doing better. We should have this as a better part of how the system runs. And it shouldn't, the burden shouldn't sit entirely with the defense bar. So there's a few things beyond the dispute system design. I think there's also plenty of opportunities for better laws to be put into place. So there's a draft law that's pending in Congress. It's likely to continue pending. The effective assistance of counsel in the digital age. This was proposed to protect confidentiality of email communications in the federal system. So it's limited to the federal system, but it could have influential effect if it were to pass, and certainly would help in the federal system. And there are more email communications from what I can gather that happen at the federal level as compared to at the state level between lawyers and their clients. There could be laws put in place, and this would have to be both statewide, and there could be opportunities for federal improvements in federal legislation that clearly protect the privilege of attorney-client communications and really spell out clearly that this is protected communication, although one would think we already have that, but there's room for improvement, and putting some clear laws on the books would help. And laws to prevent the use of recorded attorney-client communication in any context, including in plea bargaining and trials. So right now, if there's a recording of communications between a lawyer and their client, there's 4 basic remedies if it's found that it shouldn't have happened. One is to exclude the evidence for trial. I don't think that's much of a remedy when most cases don't go to trial. Right? So that's not particularly helpful. Second is the court can order the recording to stop, which is an after-the-fact thing, and there isn't great, the lawsuits that have been filed, there are continuing violations after the lawsuits, after they settle, because most of those lawsuits don't go to trial either, right? After they settle, there's continuing violations and inaction in fixing it. The third standard remedy that exists is the recordings can be destroyed. Not particularly helpful if if the DA has already heard the recording and it's already impacted, for example, their thinking in the plea negotiation process. And the fourth is one that's pretty unusual, but the case could be dismissed if there were illegal recording. So better laws could help to give a little bit better remedies there. A third area, right, improve the technology, right? In all of our daily lives, we have a variety of ways to talk to a variety of people. We can choose to do it on the phone. We can choose to do it by text messaging, through whatever social media apps we've got, through video and in person, right? And there's no reason why we can't expand what's possible for those that are detained. In my view, right now, we're basically operating in a 19th century form of communication. Right? It's in person or it's by mail. It tends to be where how most lawyers are reliably communicating with their clients. So one simple thing, we all go through these call menus. Anytime you call anywhere, almost, you know, if you want to talk to customer service, press 1. If you want to talk to whoever, right? And there's a series of things where we have to press different numbers. This technology is out there. It's been out there for decades. It's not that hard. Why couldn't this exist in jail calls, right? That person who's detained calls, they're calling their lawyer. If you're calling your lawyer, press 1. If it's a family or friend, press 2. Now, there's questions on how do you verify that it's actually the lawyer being called, and that's a technology question. And there are some of the things that's come out of the lawsuits is that there should be lawyer phone numbers should be provided so that the telecommunication companies know not to record those calls. So there can be versions of that built into this, but built more effectively. And there's been challenges that they're not getting the numbers that they've been given into the system quickly enough, and so the calls are still getting recorded. Another option could be dedicated phone and video lines within facilities so that it goes, and for those that have public defender's office and where a lot of the communication, that won't take care of everything because there's other lawyers outside of the public defender's office, but it would be a help. And if it's a dedicated line, then there's no question who they're talking to. They're talking to someone in the public defender's office, so it should be fully protected. Since we're sitting so close to Silicon Valley, I'm wondering if maybe anyone in this room has an idea of some better technology solutions, right, that I could be building into this. So I welcome any thoughts there. Another way that we can improve this is prosecutors need to stop using this stuff unless they've got a court order that says they've got a right to. Right? And it seems like it's not that hard. If you want to listen in on something, you can get a court order. Prosecutors, law enforcement get them all the time. It's actually not a huge barrier. We know this, right? You can get a court order. So why not here and why not in this context? And unless they've got a court order, prosecutors, in my view, can and should have, at the very least, if there isn't going to be a law that prohibits the use of it, they should be internal office policies that say we're not going to use this, we're not going to listen to it. Unless we've got a particular reason and we've got a right to, we're not going to listen to this stuff. Instead of listening to it and then using it, which is what's been happening in a number of jurisdictions. For defense lawyers, and like I said, I think one of the challenges in this area is there's a tendency to want to look to the defense bar for the solution when they have the least power in terms of making solutions in this area, right? And they're the ones that have already been saying this is a problem. In a variety of ways, they've already been saying this is a problem. So I don't think that the burden sits with defense lawyers, but there may be still ways that defense lawyers can help. And one of those may be looking for other opportunities and ways to be bringing some of these class action lawsuits. Defense lawyers often are the first ones that know there's a problem. Right, and so being the ones that can bring this forward, they may have better information, and there may be some better partnerships with some of the groups that may be able to fight civil cases, because public defenders' offices don't generally bring civil class actions. So the public interest law firms and groups that may bring those lawsuits, building some better relationships, may bring more of these cases forward. Okay, so that's a very quick rundown of the paper, and I would love it if you've got questions, comments, thoughts. So I'm opening it up. Someone's waiting to see who's going to be first. Yes.
I'm trying to formulate this correctly. And
Okay.
you also You mentioned that perhaps some of the solutions are non-monetary solutions and have to do with the court. But once those orders are made, who do you believe would be the best to monitor and make sure that what needs to be done is getting done? And what do you recommend that they do in order to do so?
So I think the question is first, what's getting ordered, right? What are the changes? So in some of the lawsuits, what has been ordered is that the telecommunication companies should keep a list of phone numbers for defense lawyers, and that those phone numbers, there should be no recording on those phone numbers. And that has not been well monitored from what I can tell from the lawsuits that have already settled. They aren't doing things like consent decrees, which have like ongoing monitoring attached to them, which you see with some other kinds of violations. That doesn't seem to be happening with these lawsuits, and so I think there could be better post-settlement monitoring, and that could be built into the settlement itself. Right, so that the telecommunication companies have to come back and say, okay, we've put all these numbers on the list, and if there's failures to put them on, that there's a system in place to call them out on it and get them to do it, right? Instead of just having a lot of complaining that they're not doing it and no clear process to hold their feet to the fire to live up to the settlement that they've agreed to. Right, so I think that could be one thing, but I think it does need to be looked at. We talk a lot in dispute resolution, right? Everything things need to be individualized, right? How are you looking at it? What's the system that's in place, and then how to improve it? So if we were to get, say, dedicated lines, and we know those aren't getting recorded, then it's really a question of what's happening with other lawyer-client communications. So for those that aren't being represented by, say, a public defender's office, or are those phone lines going to be available for the conflict lawyers who might be coming in to handle some of those cases? Could they go into the public defender's office and use those lines too, right? So it could be a variety of things depending on what are the possible solutions. I think one of the challenges with this, as with everything in our criminal legal system, is that there's no one approach. Every county is going to be different, and you can put some blanket prohibitions, I think, in state laws and federally, but how it's going to work in practice, like everything else, is unfortunately going to be county by county, and this does create challenges figuring that out. Yes.
In forming a dispute dispute system design, who is the decision maker who are meant to initiate those meetings? Is that a judiciary decision, legislative? Who can actually implement those designs?
So I think what makes sense is it's initiated by judges. They already have planning systems in place to some degree, right? And it's really about expanding the circle of who they're talking to, right? And there are some in some of the survey responses I've gotten, and some of the folks I've talked to since I've done the survey. I think there are some courts that are just naturally doing it. They are taking into account defense lawyers and prosecutors, and they may be reaching further and actually talking to the jail to find out what are the constraints and why are these things not happening in other contexts, not so much in this attorney-client communication context. So, because the courts are the ones that are ultimately running these things, I think it does make sense that they are the ones that plan. The issue is not that they're not planning at all, but are they planning in a more comprehensive and inclusive way? And could they? And I think the answer is yes. So if a presiding judge says to the head DA and the head public defender and whoever's working in the private defense bar, who they usually have some sort of loose, at least, organization, and says, I want to have a meeting about how we can improve attorney-client communications, they're going to show up to that meeting. Right, so I don't think there's a problem with getting buy-in from the various stakeholders, but if the public defender's office called the meeting, I think there's a problem with buy-in, right? So the people who've got the power probably to get the buy-in and to do the planning and to really use a dispute system design approach are going to be, I think, the courts. I think they're the natural ones. But there could be different counties that, for whatever reason, are working a little differently. But I think generally, I think that would be probably how it's going to work best. Yes?
You didn't miss this, but how are defense lawyers spotting when attorney-client communication has been revealed to a prosecutor?
You didn't miss it. So it's hard. And I think this is one of the challenges of it. Now, one of the ways, I got this in survey responses and it also came up in lawsuits, is that defense lawyers have a right to discovery from the prosecution, right? And where and how it works is different state to state, right? But if what generally is happening is that the prosecution turns over discovery, right? And so they're turning over police reports and other evidence that they've collected. Well, defense lawyers have gotten copies or transcripts of conversations they've had with their clients in jail as part of prosecution discovery. They then know that the prosecution has this, right? So is that happening all the time? Is it reliable so that you can say, well, if I haven't gotten it in my discovery, it hasn't happened? No. But that is one way that defense lawyers have found out. There's also been discovery of the problem when there was an investigation for other reasons, and it's uncovered that there was, say, widespread recording in a jail that wasn't intending to do, it wasn't supposed to be, it wasn't part of their process, but they were. Like, there's one case that's in the paper coming out of Kansas where they were doing an investigation on drugs getting into the jail, and they were video recording all of the attorney-client communications during a 6-week period, and there was a later investigation that uncovered that. So it's hit and miss, which is one of the challenges of it. If you don't have a good system in place that is protecting, then it's going to be hit and miss to uncover when there's violations. Yes, please.
Regarding the video communication, do you actually believe that it could get more secure? See, I'm of the opinion that it's not, and that it makes people more vulnerable, and it will always make people more vulnerable. Because you've entered into an arrangement where you're video recording somebody that would never have been recorded, and the public would not have known who that person was. Only if you went to a court hearing and you see the back of their head and stand in front of the judge. Now you've got this video surveillance that is communicated, however, line is who's ever contracted with the county to provide this service. There is no way you can stop them from going to another party, to another party, to another party, where these images can start showing up all over the place. And whether it compromises that particular person or somehow people backlash against the whole county or whatever. But I'm of the opinion that, the old-fashioned phone, which is just a dedicated line to here, sure, they can record it off and on, but it's not going out into the public in any way, not like in video.
And I think we've got wider concerns with attorney-client communications in our electronic age, right? And it's something that lawyers who are working mostly in corporate transactions and corporate work or whatever, they've got those concerns too. This is not an exclusive to what's going on in the criminal legal system. And there are concerns with videos. When you're having a video conversation, someone can be recording that and you don't know, right? And there are always those concerns. There can be, if you're on a Zoom call, you could turn on your camera and record the whole thing, and no one's going to know you're doing that, right? And so there are those concerns. And I think also when we're talking about how to plan for this and how to improve the situation, it's about how do we make it better, understanding 100% guarantees are impossible, right, in any of this. But certainly we can do things like prohibit the telecommunication provider itself from doing the recording. Right, that seems like that should be possible to do. Having prosecutors take a principled stand that they will not use information that they don't have proper access to, that there hasn't been a court order issued for a wiretap, for example. That seems to me that's something we could do, right? So can we protect 100%? No. And are we going to be behind on this as technology continues to fly forward in ways that we're always behind on? Yes. But can we do better? Yes. And I think we can do better in ways, because I think part of the question is, can we do better in a way that at least gives enough trust by defense lawyers that they have more options about how to talk with their lawyers, right? And so that, talk to their clients, so that their communication isn't so onerous and so difficult. And in this era, I don't know why we're not doing better. Right? We do better in a whole variety of other contexts, and we should be able to do better here. But I agree with you. It's never going to be 100%.
And so that becomes then the question of how defense lawyers and lawyers in general need to think about how they're conveying information, what information they're conveying, in what forum. And it may be that there are certain communications you don't have unless you're face-to-face and you really have some sense of how protected that communication is. For lawyers across the board, not just in this context. Yes, please.
On the topic of like getting to that 100%, which method do you think gets us closest to that 100%? Is it the software? Is it private rooms? Is it the tablet? Like what? I guess I'm wondering what method gets us closest to that 100%, but also is something that everyone can get behind. Like there'll be the least amount of fight in proposing whatever the new system is.
Yeah. So I don't tend to think there's ever one thing when we're talking about the criminal legal system, right? I think that generally it's too complicated and complex for that, and so it's a question of a variety of things. So even in this, when I'm looking at what are possible ways to improve the situation, it's not just one thing. I think a variety of things ideally would be at play at the same time. And what will people fight against the least, right? And this is really a dispute system or dispute resolution question, right? Where are people's interests, right? And what might there be a joining of interests so that they're going to see the value of changing or doing something in a particular way. And I do think that the joining of interests here is that the courts, the prosecutors and defense bar all share an interest in having efficiently managed court systems, not having cases go on longer than they need to, being able to manage that for their clients or for the state. And courts are under constant pressure to manage cases efficiently, and what's their caseload, and the data is kept, and judges are put under tremendous pressure. And so I do think that this is why one of the reasons I talk about it in this way, because I think that there's a common interest in getting a better system that's going to make it more efficient. Now, is that my favorite argument? No, but I do think that there's a common interest, and if you can bring the conversations to that, I think that you will find less fighting back. Now, there's always the question, what does that mean for budget, and what does that mean for who's in charge of what? So are you always going to have a complete meeting of the minds? No, but I think there are certain things that the courts say, establishing dedicated lines, there may be costs to that, but making sure that at least the telecommunication providers have clear and updated lists of phones that they're not going to record, that seems to me like a really easy low-hanging fruit, although it's been extraordinarily complicated actually have happened, it seems. But that seems to me that's something that everyone could be getting on board with that, if we're talking about judges, prosecutors, defense lawyers, and the county jail.
Cynthia, there's a Zoom hand now as well.
Oh, a Zoom hand, okay. Hero. Wonderful to see you. Oh, you're on mute.
Likewise. Hi, Cynthia. Thank you so much for joining us. We're especially pleased to be able to have you here as an alumna of UC Law SF. Really happy about this coming together. So I am a Luddite when it comes to criminal law, so forgive me if this question is betrays my ignorance. But it strikes me that you've really identified a great issue, an issue that is, really goes to the core of so much of what it is to practice criminal law, especially on the defense side. It's kind of surprising to me that this hasn't come up earlier. Or maybe it has, and I'd be curious to know what those debates have engendered. So part of my question is a twofold question. One is sort of how new is this development? At first you talked about COVID and jails shutting down and that kind of impinging on the communication. But if we're focusing on letters and the risk of a breach of confidentiality there, and the problems around efficiency of in-person visits, it seems like those things have existed for a while. And so I guess I'm curious to know, what is the debate so far been like, and what kind of issues have been raised, or has it just been off people's radar screens entirely? I guess related to this is partly to do with this DSD, the dispute systems design issue, which you raised, which I think of as kind of a bottom-up approach. But I'm almost wondering, if there has been a history here, are there maybe other top-down approaches that could be added to this mix? And one question I have, and again, this is going to betray my naivete about this area, is there some kind of federal constitutional issue that all of this implicates? It seems to me if a suspect is not able to have good communications with their lawyers, it almost, I don't know, is an ineffective assistance of counsel issue, or maybe impinges on your right of confrontation or adequate confrontation. I don't really know, but I guess I'm wondering, is there a federal question or solution out here that could also remedy a lot of these kind of coordination problems you have in a largely state-based system? And again, I don't know if any of that makes sense, but those are the questions that came to my mind.
Yes, they totally make sense, and they're hard, I think, is one of the challenges with this. So first of all, is this a new development? No, not at all. There have been these problems for a long time, and like I said, a lot of the lawsuits that I talk about in the paper predate the pandemic. This is not a pandemic problem. It became a stronger issue in the pandemic when there was no other option, right? When the in-person option was taken off the table, because that's the default way that the defense bar through the years has dealt with this problem, is they have just met in person. And you see that a lot in the criminal legal system. A lot of things, the default is in person. So it's not new. There's been an awareness that this has been a problem well before the pandemic. But it is surprising to me. There's some efforts to do things to improve it, like this federal legislation that's pending dealing specifically with the emails in the federal prison systems, attorney-client emails. But it really is not uppermost in the concerns, and you can see on some levels why. I mean, we've got so many serious issues in our criminal legal system that this one doesn't percolate to the top when we've got some other ones. When we're dealing with questions of mass incarceration and some of the other issues that have been more present in people's thinking. And this is a problem that the practicing lawyers experience day in and day out and are very well aware of, but it doesn't mean that gets translated to legislative change, and it certainly doesn't get translated to scholarship. So, this is, defense lawyers are too busy to write law review articles, right? And so it really, when I first started looking at this, it's really been stunning to me how little has been written in this area. I would have thought there would have been more. Because it is a long-standing issue, but it hasn't been, and I think it's also it being, as you put it here, off people's radar. I think it has to do with how things happen in our criminal legal system so much, which is the defense bar and public defenders are the front lines of trying to make change in a whole variety of areas, and are is very difficult, right? They're not having great success. It's not like they raise a problem and everyone says, oh my goodness, it's such a serious problem, let's deal with it. It's fighting and fighting and fighting to get some recognition of the problem and to get some ways to improve the problem. And that's what you're seeing in this. There's been regular lawsuits, there have been complaints that the defense bar has raised, and private defense bar, public defenders. But it's piecemeal, it's case by case, it's office by office. It hasn't really gotten the bigger exposure to lead to the bigger solutions, statewide or nationwide. And it's one of the challenges, and I think it plays into what happens so often when we talk about our criminal legal system, which is a lot of people don't have a lot of sympathy for people who get pulled into our criminal legal system. They don't care. They're criminals, right? That's what you hear more often than not. Although what we're talking about here are people who are accused of crimes who have not been convicted. We're talking about the ability to talk with their lawyers before trial, right? Or before they plead out. But there's very little sympathy, and we've seen some sympathy garnered in things like the issue of exorbitant costs for prison calls to family. And jail calls to family. And we've seen some changes. California is a state that's made some changes in that in response to widespread concern about how much it was costing to make phone calls out of prisons and jails. But I think it is a challenge. It's not on people's radar, and it's a challenge to get it on people's radar, along with all the other issues and concerns in our criminal legal system. And in terms of the dispute system design and how this can be at play, I think it's also a challenge in the sense that we don't have great planning in our court systems. And we can say that, I'm sure, in plenty of other areas in the public sector, right, that we could do better. But I think it continues to be a problem. And I don't see dispute system design as being something that has to be bottom up. I think it can also be top down. And I think part of the advantages of talking more about dispute system design and having more awareness of it is the idea that this is an approach that can be very helpful in a variety of contexts. Right, and to think about it more broadly and how we can use dispute system design in a broader way to try and improve situations in a variety of contexts in our society, not just in small, narrow areas. So it could be more widely used. So I don't know if that helps, Hiro. Okay, so we've got one question back and then Clark. Yes,
so
you're first.
I'm wondering in your research if you looked into any other countries or models of dispute system design or scholarship in maybe places where they are addressing this better. And I'm thinking, like, I looked a little bit into like Germany and Sweden. Maybe it's because of the GDPR, but they have stronger protections of confidentiality and informing people about breaches if they happen. And I'm wondering if you did look into it, and if it is maybe driven by what you mentioned, that at the root of it, we feel as the society, there's more of a right of people who are incarcerated to have their privacy protected in those countries or here, or what is the difference? Like the places that are doing it better, why are they doing it better?
Yes, I've looked very briefly at it. I was curious what the European Union was doing because they tend to have some regulations that we don't, right, in a variety of areas. And so I was curious if they've regulated this, and there's some, not very much in this. And I do think often when we're looking at questions of how our criminal legal systems work, culture matters. Right, and how people look at the criminal legal system and what role they see for prisons and jails. So we know that there's much lower incarceration rates throughout Europe. Pick your country, it's much lower incarceration rates, and then when you get into like Northern Europe, it's lower still, right? So if you're looking at Scandinavia or Germany, like the examples. And they've very different ideas in terms of how they treat people who are incarcerated and how the prisons work. I mean, they have counselors, and the idea is the prison guards should be counselors to help them rehabilitate, right? That's not our way of looking at what prison guards are doing in this country, right? And so it has, or even jail, folks in jail. So part of this mindset change affects, right, what is going on and how systems are working. So I think there are a lot of areas in criminal procedure, criminal practice, where it's very interesting to look and do comparative work. I think it's challenging when we're looking in this particular area because it's so bound in what our existing problems are, which doesn't mean it wouldn't improve to look outward and say, okay, well, then maybe there's a good model someplace else. And certainly we do that a lot, and other countries do that too, of looking for a good model. So, for example, plea bargaining. A number of countries have adopted plea bargaining. A number of countries have adopted drug courts, which is a problem-solving court movement that started in this country. So there are examples of sharing and transplanting across borders. This area, I wasn't able to find a lot. So if you know more and can find more, I would be very interested, because what I found was really not enough at this stage to put in the paper in any meaningful way. But I would love if there were other, if anyone has an idea of how to do more of that. I think it's certainly worth looking at. Absolutely. Clark.
Actually, I'm grateful to Hannah for making me think about this, which is, you mentioned there's not a lot of sympathy for prisoners, and I wonder if you could talk a bit about the demographics of prisoners versus the demographics of the people who are decision makers, in particular, in terms of the racial profile, the class profile, the education profile, maybe even city versus urban.
Yeah, so I don't have all the numbers at my fingertips, but we know, right, that a much higher percentage of people of color are in our criminal legal system than generally in our society. A very high percentage of people who are pulled into our criminal legal system have cognitive disabilities, substance abuse problems, mental health problems. So just in terms of who gets pulled in, it tends to be the people who are the least advantaged in our society and who have problems that may have nothing to do with crime itself, but that pulls them into the criminal legal system, and particularly with the petty things. So someone who's got serious mental health issues may be homeless, and that may mean they're getting picked up for trespass kind of offenses. That's something you see that cycle a lot. These petty offenses they're getting picked up for. And this is a piece of what's going on in our criminal legal system. If any of you have ever been to a courtroom, in a criminal courtroom in this country, it is stunning the disproportionate representation of people of color in for defendants. If you're at an arraignment court, like an in custody arraignment court, I lived for a few years in Appalachia. It looks a little different there, right? But because there's less diversity in that part of our country, but racial and ethnic diversity. But in terms of who's practicing law, right, fortunately we're getting more diverse, but we're still not as diverse as we should be, right? And who's on the bench, the same thing. What we do have in terms of socioeconomic status, we're talking about middle class, upper middle class people, even if people didn't start there by the time they're practicing law, that's where they are, right? So we do have big differences, and it's one of the challenges when you look at how, say, for example, prosecutors are doing their jobs in empathy, and we know that people are more empathetic to people that they think are like them, whatever that means, right, to be like them. And so it is a challenge when you've got people who look like not like them at all when it's the power and decision makers, right? And that is the bulk of who gets pulled into our criminal legal system, and it creates challenges in terms of a variety of things, including in plea bargaining, and including in how concerned are we about things like, can you have a confidential conversation with your attorney, and presumptions of guilt instead of presumptions of innocence, which are a routine, I think, part of how our criminal legal system works. Not how it should. Yes.
Kind of a related, totally unrelated point, rather. You were talking about how at the federal level there could be this protection that would be legislated. I was thinking about the dispute systems design and how it's done in other areas. So I'm wondering, so in the environmental area, for example, when there's a pollution site, I learned recently from another speaker in this series, Michael Moffat, that there's a process that encourages people to bargain amongst themselves and provides various incentives there. Do you think that at the federal level or at a state level, because that could regulate county jails, the answer is to sort of dictate a particular substantive area, or perhaps to dictate a kind of a process that would require that there be a meeting of the various stakeholders and they be able to report on that?
It could be. It becomes really challenging, I think, to mandate that because it's so out of how we've been doing things, right? And then you hit pushback and resistance to it, which is a challenge. I think that if you mandated it, would you see it? Would people? I think maybe there's a little bit of an analogy to some of the mandatory mediation, right? So you mandate it, it doesn't mean people are going to come to agreement, right? They're going to go sit in a room or sit in two separate rooms, however the mediation is working, right? More likely two separate rooms. So, mandating that people engage in a process doesn't mean they're engaging in it in good faith. And so I think there is a challenge with that, which is not to say it's not worth trying, right? Because maybe something will stick if you require it. So, yes.
Yeah, so I was thinking about, it's more so in line with this question, in terms of particularly vulnerable groups and how they're impacted, particularly like undocumented immigrants. So I was wondering how inefficiencies in plea bargaining as a result of compromised confidentiality and how that affects these groups and what sort of protections do they have, because it seems like the groups that are being impacted for the most part are, like I'm assuming U.S. citizens and, people who have like a documented status. So I was wondering, like, for those other groups that are not, I guess, represented by the majority, like how do we resolve that issue? Or do you have any ideas as to how they can better protect themselves, or where can they get help from?
Well, in terms of the confidentiality of attorney-client communications, or more generally in our criminal legal system?
More generally for like undocumented.
Yeah. So we don't have uniform rights to representation, right? So in the criminal legal system, there is a right to representation, which cuts across people who are documented or not documented. That's not at all a question. It's that they're charged with a crime that qualifies for the legal services. And I think there are wider questions about how do we look at legal services and the right to legal services. And this is where it is interesting to look at some of the European examples where they have a much wider view of rights to legal services in other contexts beyond criminal. So I think that there's great value to looking at that, absolutely. But I also think that's another question. And we did talk earlier about what raises questions about money, and certainly that it's hard to get away from the money question if you're going to open up who's got access to having lawyers as a right, which means the state has to provide it, which doesn't mean they shouldn't, but it does make the conversation more complicated. Any others? I think we're at time pretty much.
You actually have 1 minute longer, which I'm
1
going to
minute.
take. Thank you. So thank you very much for such a
Thank you.
innovative paper. And thank you to those of you from places elsewhere in the law school who decided to come here and ask some really terrific questions. This is part of a series of papers that grew out of a poll that you did that was really innovative in getting in this data. And it's really kind of interesting that you posed it as a large question, not realizing, if I understand it correctly, that this would turn out to be the answer that would be so significant. And it is, to some extent, to loop back to Hira's question. The paper process itself is a bit bottom-up rather than top-down.
Yeah, absolutely.
So thank you very much, Cynthia, and thank you all for attending, and thank you all in Zoom land and those who will be watching this on recording later. Thank you.
Thank you.
Thank you.